Alex here with a legal nuts and bolts video on the Mootness Doctrine. I'm going to start with an example from one of my child custody disputes because I think it is going to speak to my audience better rather than getting really technical. But I do want to remind people that mootness, just like any other legal principle, has a lot of technical details involved, and to always look into those technical details in your specific state, in your statutes, rules, and case law. But for the purposes of this video, and because examples often make sense much more quickly than actually just bringing up like the academics of it all, I'll start off with that example. So what happened in my child custody case was that I was dealing with my ex who was not turning over our son's medical benefits cards. I filed a motion with the court asking the court to order that both of us reciprocally, both parties have an ongoing duty to disclose medical benefit cards. Not just right now, but ongoing. So as in like from now until our son's 18. What happened in response was my ex filed an opposition turning over the cards. So mind you, I'm not going to go into all the little annoying details like how many times I asked by email and text and was told no and refused, and now I file a motion and all of a sudden her attorney gets involved and realizes how much of a knucklehead she is and orders her to turn the cards over to me. That's all neither here nor there. The point is that in the opposition, what her attorney said was not that she doesn't have any kind of legal obligation to turn the cards over. It was that the cards have been now turned over. And since now they've been turned over, the issue's moot. There's no point in the court addressing my motion because I asked for the cards and they gave me the cards. My response on reply was that mootness does not apply because I'm not actually asking in my motion to have those medical benefits cards and that's it. I'm actually asking for a specific order that requires both of us to exchange medical cards anytime it becomes an issue, like there's new cards or new insurance or whatever. Obviously, what I was seeking was not just a resolution on this issue now. I was seeking a resolution on this issue going into the future, which is logical, makes more sense. If you're going to go to court, you may as well resolve the issue now and in the future, because that kind of order would have had effect going forward. For example, if she changed insurance or there were new cards, I wouldn't have to come back to court and file a second motion asking for the cards. I would be able to rely on the previous motion that, if resolved by the court and entered into an order, would say that we always have to keep updated on the medical benefits cards and stuff. Well, the court erroneously applied the Mootness Doctrine, and this was at a time that I did not understand how appeals worked. So I got really frustrated and I just kind of let it go. If I knew now what I knew then, I would have filed an appeal and most likely won that appeal, because the actual case law that discusses how the Mootness Doctrine works would have been in my favor. The case law itself states that the issue requested has to have been resolved by the occurrence of subsequent events or something like that. I'm paraphrasing a little bit. Obviously, I did not request a handover of the cards just one time. So that would have been a question of law that I would have won on appeal. If anyone wonders what I mean by question of law, watch the video standard of review. I go into that in a lot more detail as to what the relevance and why that's a big deal. When you bring an issue to the Supreme Court or any kind of appellate court that's a legal issue rather than a factual issue, the analysis conducted as to whether or not the court will reverse the decision of the lower court is very different if it's a legal issue versus a factual issue. Anyway, the court applied the law incorrectly. That's not how the Mootness Doctrine works. The other thing I was going to mention is that there are exceptions to the Mootness Doctrine. Sometimes, legitimately, and I say legitimately because it didn't happen in my personal example, but in other cases, I'm sure the Mootness Doctrine would apply under certain situations correctly. Yet the court may want to invoke one of the exceptions and make a ruling on the decision regardless. The exceptions, and again, I'm not going to get technical, the basic gist of the exceptions is that the issue that has been rendered moot is an issue that would, because of the nature of how quickly it comes up and gets resolved, be a particular issue that would almost always be moot just because of the nature of how slow the court system is and how long it takes the court system to give attention to a particular issue or claim and how long it takes the court system to resolve that claim. Because of that, it's capable of repeatedly avoiding or evading the review of the judge or the appellate court or whatever. If you can show that, or if the court believes that, the court can decide that an issue has been rendered moot. However, it is going to still render a decision on it because of the exception to the mootness doctrine. I can't really think of an example on the top of my head, but if you look into your case law and you look up mootness doctrine, you will find examples of how it's applied, and you will also find examples as to how the exceptions are applied. I think there may be other exceptions to the mootness doctrine out there, or maybe it's more so additional things that they consider on top of the fact that it's a particular issue that is capable of repeatedly occurring and evading review, because even though it comes up repeatedly, it ends up getting resolved very quickly. They may look into things like how important it is to the public policy of your state, or how many people it's going to impact if the court does not render some kind of ruling or decision on it. So in my case, mootness came up at least 4 times, and I can only really remember the judge making a mistake that first time. I believe I was able to fend off mootness the second, third, and fourth time. I'm going to talk more about that when I go into the My Docket series, which I'm going to go ahead and start when I have 3,000 subscribers. It'll be a while, I'm sure, probably another few months. But in the meantime, keep an eye out for that series. When I get into the particulars of the hearings and filings, when mootness comes up, I'll be able to address it in much greater detail. Right now it's kind of fuzzy because it goes way back. I wish that judges wouldn't use the mootness doctrine just to avoid having to do their job, which is kind of what I feel my first family judge was doing. He was the one that entertained mootness most. I can't recall my second judge having brought up mootness before, and I can't recall any of my other cases. It was mainly my first family judge. It was like he was just looking for an excuse to just not have to do his job, and so he would try to say that certain issues were moot even though they weren't. I hope that this video is useful to people from both sides of the same coin, because some people may actually want to avoid going to court on an issue that's been rendered moot. Some people may legitimately have an issue that their opponent has brought up that is no longer an issue anymore, and they may want to vacate a hearing or just close the case or whatever, and they may want to use the mootness doctrine to do so. It is a thing. It does have serious power. It does cause not only cases to be dismissed or claims to be dismissed partially, but it comes up a lot in appeals as well. There will be issues that go to appeal in the Supreme Court of Nevada that will become moot because it takes forever for an appeal to be resolved, and things will happen while the appeal is pending. Some appeals take a year, and things will happen in that year. And like, for example, say somebody fights some kind of constitutional issue with a law or something, and then the legislature changes the law while the case is pending. Well, that could render it moot. I'm not going to say for sure it does, but that's an example of how somebody could have sued on some issue that they had with a specific statute, and the legislature could have voted and changed the statute while the appeal was pending, and ta-da, the issue is now moot. It may happen in elections. A candidate may have some kind of problem with another candidate and may ask the court to do something with the ballot, and the election may come and go before the judge has made a ruling on it, and they may say that that's now moot. Of course, as I mentioned in the video, there's all kinds of technical details to look into. There's exceptions to the mootness doctrine. I just wanted people to know that it was a thing, that it definitely came up in my child custody case multiple times, that I definitely feel that it was applied incorrectly by my judge at least one time, possibly more, and that it is a powerful doctrine. I've seen it used in the highest court of our state. So it's something to look into if you're concerned it's going to be brought up in your case, or if you want to have something brought up against you dismissed or thrown out because it's no longer relevant. With that, I am going to go ahead and end this video, and I'll see you guys next time.